Dear friends and colleagues, I am delighted, even with Atalea, who is making herself heard. Our youngest student, she registered, you know, some people are very gifted. So I'm delighted to open the second CRCL, we sometimes call it CIRCLE, conference, bringing together global thought leaders in the domain of legal informatics, prediction of judgment, rules of code, or what is now hyped as AI and law, which is a domain with a long history that some would say is being overtaken by those more interested in business models rather than in academic inquiry or legal practice. The conference has been initiated in the context of my ERC Advanced Grant project, which runs from 2019 to 2024. So in a sense, this is a closing conference also. The project is on being human in the era of computational law. And that we use the acronym CORUBICOL, which is of course something to break your throat on. So we say cubicle, and we think of Wittgenstein's cube. I should have actually put up a slide to show you Wittgenstein's cube. Does anybody know what it looks like? Oh my God. So it's a cube where if you look at it, you see it going in death towards that side. And then you turn away, you look at it again, and the same image of a cube turns this side. The fun thing is you cannot look at it in both ways. And it's very difficult to control your brains to switch. Okay, so the conference aims to look at consequential legal tech, not at office law, office management software or something like that, but consequential legal tech. And that is a term I borrow from the paper by Kapoor, Henderson, and Narayanan. So we look at these legal technologies from different disciplinary perspectives. They're all key to understanding the consequences of their real-world deployment. So it's about the design and the default settings, but it's also very much about the real-world consequences. And the conference takes the position that these perspectives cannot always be taken simultaneously. So that's where the Wittgenstein's cube comes in. Sometimes you have to shift from computer science to law, from law to political economy of legal technologies. And it's not always possible to integrate these perspectives. And that's important. We call this methodology cross-disciplinary. So we're not going to make an interdisciplinary soup where we pretend that, for instance, the concept of optimization means the same thing to a mathematician as to a social scientist. Optimization in computer science, in machine learning, that is, which is a very particular part of computer science, is a mathematical term with a very precise meaning. Optimization in the real world that social science studies has very different meaning. And if you try to use the same term for both, you're going to understand both domains mistakenly. So the idea is that I'm a lawyer, really seriously learn about the methodology of computer science and respect that. Don't think that we heard something and now we know. We do expect the same thing from computer scientists as soon as they engage with the law. So this conference does not aim to compete with the more technical existing conferences like ICALE, the ACM, Computer Science and Law, Natural Legal Language Processing NLP Conference, URIC, some of which are very long-standing, and so on. It's also not trying to compete with STS, Science, Technology and Society perspectives, with investigations into the political economy of legal technologies, with algorithmic studies, etc., etc. Instead, it aims to create a middle ground where excellence from all these domains can meet, based on respect for the relevance of the different assumptions. Any discipline has assumptions, and they may differ radically. I would say that the assumptions of modern positive law are based on the affordances of text. Text as a technical infrastructure, so that's the printing press. The affordances of the assumptions of computer science are very different. They're very close to mathematics and to the way electronic machines operate. So we aim to have an exchange on the substance of these disciplines with regard to legal technologies and the law and the rule of law and their methodologies. However, the conference is not about an unencumbered exchange, to use the term of Charles Taylor. The concern here is the deployment of consequential legal tech in legal practice and how this is going to affect law and the rule of law. Lawyers should not sit on their hands when the constitutive infrastructure of societies, law as architecture, is reconfigured in ways that are more conducive to what is computable and what is executable than to what is reasonably foreseeable, legal certainty, to what is fair and contestable, justice, in a way that is both practical and effective. And those who know the case law of the European Court of Human Rights are aware that the term practical and effective is key to European human rights law. It's not about law in the books, or not only. And being both practical and effective means, good morning, that the law aims to be instrumental for policy goals that we believe should be determined by a democratic legislature. So I've spoken about legal certainty, justice, and instrumentality. And those who know their continental philosophy, legal philosophy, have already recognized Gustav Radbruch, a famous German philosopher who was Minister of Justice in the Weimar Republic just before the Nazis took over, and who developed a very interesting legal philosophy. So it is interesting that these three goals for Radbruch were what he termed antinomium. Antinomium. Nomos is law. And antinomium in this case means that these three goals, we should strive for them, but acknowledge that in practice, they may be incompatible. Now, the reception of Radbruch in Anglo-American philosophy has been an attempt to rank these three considerations, so legal certainty, instrumentality, and justice. And this is exactly what Radbruch said we should not do. We should acknowledge that in practice they may be incompatible, and that still means we have to strive for all of them, and at some point make certain decisions, but they should be informed in the end by the importance of all three. That means that efficiency and executability are not the main parameters here. Instead, the rule of law invites friction, ambiguity, delay, and hesitation as key to an open society, while at the same time acknowledging the need for practical and effective protection against monopolies of both political and corporate power. Now, that's a full plate. Today, we have a symposium on the future of computational law. Let's say the first question is, does computational law have a future? Has that future perhaps already begun? Is it silly to talk about the future because it's already with us and we don't see it because we think a legal search engine is just that? It's like a tool. But as we know, tools co-constitute, help to make the ends for which you use the tool. Today starts with the presentation by Lawrence Diver and Pauline McBride of one of the major outputs of the project, the research study. It's still in a draft state, so they are very welcoming to comments and feedback and engagement. The research study on computational law, which follows up on the research study on text-driven law that was published in its final version this summer. And basically, it starts from there saying, okay, the current, let's say, the essence of modern positive law is actually an affordance of the printing press, the technologies of the word. Now we're going to move into other affordances because this technological infrastructure is complemented with or changed or replaced or whatever, we don't know yet, by another type of technology. After that presentation, we have the pleasure of having a whole range of position papers that are available now on the website, where we asked leading thinkers in these domains to think about the future of computational law. And we asked people from different domains, existing domains of study, legal informatics, some of the conferences that I just named. But we also, for instance, invited Sayash Kapoor, Arvind Narayanan, and Peter Henderson's paper, who are computer scientists who have not really worked that much on the law. While we think that their insights are absolutely key for the law and for lawyers. So the idea of this conference and the journal that co-organized it is to invite people who are experts, who are excellent in their own domain, and that can help us lawyers to better understand both the possibilities and limitations of these tools. Tomorrow we have first the morning session, which is a set of papers that were submitted, and we selected out of the submitted papers 4 papers to be presented at the conference, and that will be tomorrow morning. Each paper in the tradition of the journal will be replied by somebody from another discipline. So the papers have been in double-blind peer review, where peer means the same discipline. The reply is cross-disciplinary, by somebody from another discipline. So the reply is not about saying you got everything wrong. That's a bit difficult to say if you are not part of that discipline. But to say, from my perspective, from my discipline, I don't know what you're talking about. I would say A, B, C, D. And then we get a conversation going. And that is the key objective of both the journal and the conference. So tomorrow, the Vice President Research of the VUB, the university here, is going to open the conference again. Why on the second day? Well, he couldn't make it today because the VUB is closed today, as you may have noticed. It is celebrating the founding of the ULB, the Université Libre de Bruxelles, on 20th November 1834. And that was a bilingual university, the Université Libre de Bruxelles. Doesn't sound very bilingual to me. Was a bilingual university. The VUB, the Vrije Universiteit Brussel, that's Flemish for the Free University Brussels, was founded in 1986 as an emancipation from the not very bilingual ULB. So we now have 2 universities, a French, Wallonic, and a Flemish speaking, and they are actually at this moment collaborating, getting together. I want to note that the founding of the original Free University was actually an act of resistance. It aimed to institute countervailing powers against the dominance of the Catholic Church in academia here. And the mission statement of the VUB until this day reminds us of the goal of this university, the explicit goal of supporting freedom of thought and expression. It was a statement made by Poincaré. And it goes as follows. I will spare you the French. I'm not sure that would work. Thought must never submit either to a dogma or to a party or to a passion or to an interest or to a prejudice or to anything, but exclusively to the facts themselves, for to submit means the end of all thoughts. I can think of a million reasons why that would not perhaps be my motto, because it suggests that there is the facts to be picked up from the street. But imagine if this were our motto. I challenge you to turn this into executable code, or to deploy predictive artificial intelligence to explain how this should apply to academic decision-making on funding, subject matter, on appointments, and on investment. Good luck. For that, we would need more concrete norms that in engineering terms operationalize the principles. That, however, does not mean that the principles are no longer relevant. Their spirit, Montesquieu, should inform the operationalizations and keep them updated, adaptive and flexible in light of the principles. And that may be easier when using natural language, because it has all these characteristics, than when using computer code or inferences based on machine learning. Because both computer code, a program written, and machine learning are glued to the past. And if anybody disagrees with that or wonders what I'm saying, you can raise that question later. So what's to be gained from computational law in the broad sense? And what direction should it take? This is what informs the spirit of today's symposium. And I look forward to an animated, detailed, and in-depth discussion. Thank you very much.